to the International Business and Law Academy. My name is Anne, and I would like to introduce my presentation on the subject of foreign non-convenience of litigation in dispute resolution. First, we should discuss a case study in order to understand the nature and functions of litigation, the rights and obligations of private parties in dispute resolution. The case that we will be discussing today is Interpain Coatings versus Australia and New Zealand Banking Group. Here are the facts. Interpain Coatings, a Wisconsin corporation, delivered goods to McDowell Pacific, an Australian buyer. The parties utilized a documentary exchange whereby McDowell would receive bill of lading covering the goods upon its acceptance of drafts, promising payment to Interpain. To facilitate this document transfer, Interpain and McDowell enlisted the services of Australia and New Zealand Banking Group, ANZ, an Australian bank. Out of concern that McDowell might fail to honor its promise to pay on the drafts, Interpain instructed ANZ not to release the bill of lading unless the bank would guarantee the debt. ANZ misunderstood these instructions and delivered bills of lading to McDowell. After taking possession of the goods, McDowell refused to honor its obligation to pay on the drafts. Interpain filed suit against ANZ for negligence and breach of contract. It brought suit in Illinois Federal District Court because ANZ maintained an office in Chicago and thus could easily be served with process there. ANZ asserted that the U.S. District Court was a highly inconvenient forum in which to litigate Interpain's claims, and suit should have been brought in Australia. So the issue here that we will discuss is, should the U.S. District Court dismiss the case on the grounds of non-forum non-convenience? We would like to invite you to discuss this case together. You can talk specifically about the case, about its disputes, and at the same time give a justification of the applied theories that you might use. Please, everyone. Ruby?
I think that since Interpain Coatings, a Wisconsin corporation, delivered goods to McDowell, a Australian buyer, I think this is a business transaction between two businesses of two different countries. Therefore, the payments are made through foreign banks. And I think that there's a lot of risk in paying if the goods have not been received yet.
I agree with Ruby. To facilitate this document's transfer, Interpain and McDowell enlisted the services of Australia and New Zealand Banking Group, ANZ, an Australian bank. So Interpain instructed ANZ not to release the bill of landing unless the bank would guarantee the debt.
Torrin, can you build on this?
But ANZ delivered the bills of landing to McDowell anyways. After taking the possession of the goods, McDowell refused to honor its obligation to pay on the drafts. Interpain filed a suit against ANZ for negligence and breach of contract.
And what happened next, Ning-Wan?
Yes, Interpain brought suit in an Illinois Federal District Court because ANG's maintenance an office in Chicago and thus could easily be served with process there.
Thank you everyone for their specific discussion based on the case and very clear analysis of the situation. But before answering the case question, we need to review the theoretical part of the research paper. Ruby, can you start us off?
Since ANZ asserted that the U.S. District Court was a highly inconvenient forum in which to litigate Interpain's claims and the suit should have been brought to Australia. Hence, I think we should clarify the principle of inconvenience forum and determine where the adjudication is appropriate.
John, can you tell us about the two situations, please?
So when a contractual disputes arise between two parties, each of the party opts for the court offering the greatest tactical advantage. This frequently results in one party questioning the suitability of that particular forum, or after a race between each of the parties to file a claim in its favorite locations, two separate courts might be called to simultaneously try to settle the disputes. So these two situations, an inconvenient inconvenient forum and parallel litigation.
Soren, can you please explain what forum non-convenient might mean?
Forum non-convenient sometimes in a court meets a jurisdictional and a venue of requirements, but the trial would be more convenient and just if they were conducted in another forum. Under these circumstances, a judge is permitted to dismiss the case under the doctrine of forum non-convenient.
That is correct. Ms. Wan, can you please elaborate on the interests of the public and private?
I think that U.S. courts utilize a three-step process that considers certain private and public interests. The courts look to see if there are any alternative forums which subject matter jurisdiction over the dispute and personal jurisdiction over the defendant. In this part of inquiry, the courts weigh various private factors to evaluate the relative advantage and obstacle to a fair trial. The lawsuit should be removed to another forum. The courts consider certain public factors.
And I would like to talk about the private and public factors that Ms. Nguyen have suggested. So the private factors would include A, the ease of access to evidence, B, the cost of summoning the witness, and C, the need to actually view any premises, and D, the enforceability of the court's judgment. Whereas public factors would include A, the amount of congestion in the court is experiencing, B, the desire to avoid burdening jurors with issues that have little relevance to the community, C, the importance of having the trial in a community with a strong interest to the outcome, and D, the desire to have the case decided in a forum that is similar with the law governing the dispute.
Well, thank you everyone for the fantastic discussion based on the theories for this case. Well, now I'm going to answer the question of should the U.S. District Court dismiss the case on the grounds of forum non-convenient? The decision is yes. The application of forum non-convenient presupposes the existence of an adequate alternative forum. Interpain argued that Australia would not meet this requirement because that nation requires foreign plaintiffs to pay a security deposit to cover the defendant's costs. It stated that it did not wish to expose additional monies to risk. However, an alternative forum is not adequate only if the remedy provided there is so clearly inadequate that is no remedy at all. The financial burden posed by Australia's security deposit requirement does not disqualify the Australian courts as an alternate forum. The private factors involved in this dispute completely favor an Australian forum. Most of the witnesses, particularly on the negligent case, live in Australia. Further, the bulk of evidence is located in that country. Finally, McDowell, the Australian buyer, is located in Australia and is not subject to the processes of the US court. The public factors also favor Australia. The Northern District of Illinois has no interest in this litigation. Australian law probably will govern both negligence and contract claims. Permitting the suit to go forward in the United States will require expert testimony to establish contract principles and Australian business custom and practice. Because both private and public interest factors come out so heavily on the Australian side, this suit should dismiss under forum non-convenient doctrine. Thank you all so much for being here with me today, and special thanks to the International Business and Law Academy and especially Dr. Sung.